The purpose of this talk is to give an overview of what is known as European contract law project, but it is now clearly a proposal for legislation in the form of the European sales law. Behind this has always been the idea that we need to enhance and improve Europe's internal market, and this is the reason for most of the legislation in the area of civil and commercial law, to really release the potential of the internal market. Contract law, of course, is central to all commercial transactions and indeed to most human legal relations in one shape or another. It is a central building block of civil law. Within the European Parliament and the institutions, there have been discussions about a European contract law over many years, at least 10 to 15 years. There has been much academic discussion and interest, but of course this has to fit in to the current political context. Within the internal market, it was always felt that the differing systems of national contract law were an inhibiting factor, either undermining consumer confidence from buying across border, or too expensive for SMEs to get all the legal advice to comply with the many different regimes. And these arguments remain with us even today. With the advent of the internet and the synergy of a borderless medium with a borderless market, the failure of Europe's SMEs and consumers to engage in cross-border transactions becomes more and more frustrating. Indeed, the European Commission estimates that the loss of intra-EU trade could be as high as €26 billion per year. Thus, the ideas of a more coherent European contract law and the contribution that this could make to better lawmaking were much discussed in the European Parliament. There was reticence to the suggestion of a full-blown contract law, knowing how politically sensitive this would be, especially in common law jurisdictions like my own, where the mere idea was anathema and literally portrayed as some form of continental invasion. Academics across Europe, meanwhile, spent much time drawing up the so-called common frame of reference on contract law. This academic exercise happened with funding from the European Commission. There were ideas that the common frame of reference could be used as a so-called toolbox to inform future changes in European contract law, ensuring coherence between different directives that touched on the field of contract law. But all of this discussion came against a backdrop of the failure of the so-called European Constitution, the negative referendums on the Constitution, and the return to a treaty, a constitutional treaty. This was hardly the political backdrop against which to introduce a common European contract law, or indeed anything that might be suspected of being the starting point for the development of a European civil code. Perhaps more than anything, two elements changed the nature of the discussion. The first was the failure of the harmonisation method, which we saw particularly in the dealings with and the lead-up to the new Consumer Rights Directive. Finally, it turned out to be a rather limited directive, and this really showed how difficult it was to get full-scale harmonisation in this area. Added to this, we are in an economic and financial crisis. And in such circumstances, the need to desperately improve the functioning of the internal market could never be greater. At this stage, enter a new European Justice Commissioner, Mrs. Viviane Reding, the first time having competence over the whole area of justice. She came to her hearing in the European Parliament famously brandishing a copy of the Common Frame of Reference on Contract Law, and her message was, really, let's do it or forget it. And it also fits in with what has become her agenda of justice for growth against the backdrop of the economic difficulties. But by this time, the discussion had also turned to the idea of what has been called an optional instrument for European contract law. An option which parties could choose running alongside their national law, but not invading the national law, not impinging on it or changing it, thus being a much more sensitive way forward. It was this option that the Commission consulted on early in 2010, and the European Parliament produced its own report. In effect, the Commission consultation set out 4 options, ranging from a full civil contract code through the optional instrument to a do-nothing option. The Parliament came down with a huge majority in favour of the optional instrument, but the following important points were made. Firstly, above all, the optional instrument must have a very, very high level of consumer protection and, as far as possible, incorporate all national mandatory rules. This was a non-negotiable point for many in the Parliament, and if in future there is a lessening of the level of consumer protection, then my view is you will lose the consensus across the European Parliament. Secondly, the instrument needed to be and was seen to be one that would facilitate trade for SMEs and consumers. It's a facilitating instrument. It's not a complex transnational law for high-power financial contracts and the litigation of those contracts. That is very much not what it's about. The Parliament thought also that the toolbox would still be helpful, particularly in respect of interpreting what would be a new legal instrument. Also, Parliament felt that it might be wise in the first instance that the instrument should have limited scope, perhaps sales contracts only, perhaps online only, and perhaps only cross-border. In Parliament we debated long and hard the need also to accompany the instrument with draft standard terms and conditions that SMEs could take off the shelf to use with the optional instrument, that these terms and conditions would be available in all the community languages. We felt also that there should be a linkage with alternative dispute resolution and a linkage with other community instruments, the payment order and the small claims procedure. Lastly, the Parliament underlined again and again in its discussions and the report that this instrument needed to be proceeded with great care and with very detailed impact assessments. As a result of the input from all quarters, the Commission has now come forward with a full proposal. But we're no longer talking about contract law, we're talking about a proposal for a European sales law. That is how it is now known. And the proposal is for a regulation with a legal base in the internal market. That's important because it means that the Parliament will be a full co-legislator. Another legal base could have been chosen, but that would have cut the Parliament out, except as on an advisory basis. So this is important. It is very much an optional instrument for SMEs and consumers, for B2B transactions and for B2C transactions. It is a second optional instrument running alongside national law, but also rather intriguingly being a part of national law in terms of the application of the Rome I regulation. What will be interesting is to see how the legislative method, or what legislative method, is adopted. The sales law itself is an annex to the proposal, drafted by experts employed by the Commission over a one-year period. It forms an integral whole. What one has to wonder is, will Parliament and the Council actually start amending the annex, or will they rather indicate their political and policy priorities and then resubmit the annex to the experts? The methodology could be extremely important to the result. Parliament has decided to hold a number of hearings over the next 6 months on various issues arising from the proposal and the annex. This will be important in terms of involvement and engagement. Lastly, there has been some muttering and disquiet in some of the national parliaments around Europe that perhaps the proposal does not respect the subsidiarity principle. This is strange indeed. It must be the most subsidiarity-friendly proposal we have ever seen. It is optional. You cannot get more subsidiarity-friendly than that. What will be important is that the end result must be good. It must be usable. It must be user-friendly. If it's good, it will be used, it will be successful, and it will breed success in Europe's economy. At the moment, the consumer organisations remain sceptical, but perhaps even they are now beginning to come round. There will be interesting times ahead and interesting discussions.